time to Rosario Serra. Rosario Serra is our close friend, professor of constitutional law at the University of Valencia. She's associate dean of the Faculty of Law of Valencia and the co-director and master in human rights, democracy, international justice. She's a member of the Human Rights Institute of the same university and of the Spanish Association of Constitutional Law. Now she is with us to talk about her project on global security and fundamental rights. Please, Rosario, your 8 minutes. Go.
Thank you very much for the invitation to the organizers of this workshop. The title of my paper is Processing Personal Data on European Union Cross-Border Movements to Fight Terrorism. So the three main I can pass? Yeah. So the three main ideas or topics I'm going to talk about is how the citizens' data are used in these cross-border spots in order to fight terrorism and to tackle with this phenomena in general. And for that, I'm starting with some certain points. For example, we can say, and it's that terrorism is a global phenomenon, and this global phenomenon has several inputs. There are a lot of cross-border movements of individuals, also movement of capitals, and the controls in these spots can be really useful to struggle terrorism. You can help to stop foreign terrorist fighters or to avoid the entry of suspected terrorism or to pursue them for arrest. So the data exchange could be very useful, and that can be also serve as a warning mechanism for detection, and cooperation between different governments could be really interesting. In this area, in the area of the European Union, especially we talk about the Schengen area, several documents, several agreements and several pieces of law has been arranged at the beginning for fighting another phenomenon that is immigration. So especially if we talk about Frontex of the Schengen information system or the Treaty of Prüm, in all this mechanism, the aim was to control illegal immigration. But all of them are tools that can serve also to fight terrorism. And the data we can obtain from these databases can be really useful for fighting terrorism. The problem sometimes is that we abuse of it. We abuse of tools that are thought for control this illegal immigration, and saying that we need to reinforce all these mechanisms to fight terrorism. As we can see, and as you know, after the new wave of terrorist attacks that happens in Europe, in France, they started in France, then in other cities in Europe, several norms that were on draft were adopted in a very fast way to fight terrorism, and many of these norms were at the beginning thought to control immigration, not terrorism. But the excuse of terrorism has been used for that. Also, as a consequence of these attacks, the agreement between different states in the European Union was adopted in other, or in relation with other norms on data processing. For example, the General Regulation on Data Processing, or the directive with regard to the processing of data for purposes of prevention, investigation, detention, and prosecution of criminal offenses, among them terrorism, or the directive on combating terrorism, all of them talks about the use of data, the exchange of this data. Among them, we can find one that it's more known, probably among the people who is here, is the personal name record register. This directive established like a macro database where the data of all passengers coming or passing through European Union are collected. And here you have the proportion of the green represents the number of passengers that fly from in an internal country. The blue one represents the European Union nationals who are flying from European Union to another countries, and the yellow one is foreign people who is flying through Europe. So there are many millions of people that are being controlled, and this register and the directive established that at least these 19 points, 19 items or data on these passengers has to be collected and registered. Some of them are very normal, we can say no name, surname, but it's especially important to tackle tourism, the destination and origin, previous travels, the means of payment, if they are traveling alone or in a group, or whether the travel they use that they make changes during the trip, or all these things can be very useful for police to struggle terrorism. We not only have PNR agreements with within the European Union, we have also agreements with USA or with Australia, for example. And the problem sometimes with this is what happened with our rights. We have to pay attention to protection of fundamental rights, and that's one of the things that the European Union Court of Justice said. And it said this, especially in one of these agreements that we tried to sign with Canada. In this agreement, the court said that there were not enough guarantees for protection of fundamental rights, for protection of the privacy of individuals. So it fails. We don't have nowadays an agreement with Canada. And more or less the same happens with United States and European Union in the exchange and transmission of data to fight crime, including terrorism. Because in the case Digital Ireland, it established that the previous one, the umbrella agreement, was not enough protective for the data and of the citizen. And again, the terrorism is on the bottom, on the fight against terrorism. For what? For what's the use of this data? These data are used for profiling and blacklist people. If we go to the directive, it says that profiling means any form of automated processing of personal data consisting of the use of personal data to evaluate certain personal aspects relating to a natural person. And and with this I'm finishing. But the consequences of this is that for the rights is that it establishes an scrutiny of movements. It can suppose an entry denial or an asylum refusal. It supposes a reinforcement of registration and control of in borders of people, with several risks for individuals, for example, stigmatization of certain groups of people, discrimination, treatment, even false positive or commission of error. So the main closing remarks I would like to underline now is that the tourism needs a response that's obvious and it's a global risk. And the data exchange on the transit of individuals across the border is an extremely useful tool for that purpose. But we cannot treat immigration and terrorism as the same phenomena. One is a risk, the other one is a challenge. So some of them can be useful, but we have to take care, and we have to take care with fundamental rights and to safeguard them, and not forget that principles governing data processing in the counterterrorism policies exist, and this mechanism and this tool has to be used only when needed, and we can never forget proportionality. I finish with this. Thank you very much.
Many thanks to Rosario. Please teach me how to do these splendid slides that move on the steps like the heart, like the sun. I don't know, I envy you a lot. Beautiful, beautiful, and very clever. Just to underline one concept, a lot, but just one concept. She has stressed that immigration and the terrorism are considered as the different sides of the same coin, and of course it is a great mistake, the same mistake that has been made by President Trump with his bans. And as I said in my introduction, it means that we don't have the culture of rule of law, but the culture of suspect and of illegal presumption and the punishment of intention and not of the conduct. The next speaker, please.
Thank you. Now, please, I'd like to give the floor to Andrea Sherbovic, National Research University, Highgate School of Economics. I met him during these days, please, and it's very interesting, his approach, because it's first of all technological based and then constitutional law based. It's very difficult to combine the two approaches, and he will say why the academia sometimes is divided between technological experts on the one hand, the constitutional law on the other one. He tries to fill the gap. I think it's a very good cultural approach. The title of his paper and presentation is which is the title?
The title is
National Sovereignty, Security, Internet Governance. It's interesting because, as he will explain, in Russia there were many security concerns, and exactly for this there were some way of legislation that had really, in a way, affected fundamental rights, especially privacy. I've written a paper in German Law Journal with Oleg Soldatov, striking the balance between human rights, online state security concern, the case of Russian comparative context. I'm really curious which is your perspective on it, because I think that Europe, Council of Europe, but also European Union should be very worried about this waves of legislation that have been a little bit outside the media focus, but I think it's important to speak about it. Please, the floor is yours.
Thank you very much. Professor Pollicino, thank you very much for inviting me to this workshop. And I'd like to discuss a really stressful problem in Russian civil society that is due to the security regulations, due to anti-terrorism laws. There are real strict problems in human rights of internet users. So here is the next slide.
It doesn't work very well. It's better.
Okay. So, when we established the United Nations system, we established the fundamentals for human rights protection for everyone, which made totalitarian practices unacceptable for for all societies. But 21st century has new challenges for this concept. For example, the issue of internet and the issue of evolution of internet, especially in states like Russia, is quite a tradition, new for all Russian society. but also internet has truly global characteristics that is supranational by nature. It is international, and it's not really well. This concept is not really well understood by the Russian politicians, by the Russian lawmakers, and this because Russian Federation provides the principle of national sovereignty, and this national sovereignty, this concept of national sovereignty, is very important for dealing issues with the internet. Also, there is the concept of which developed that there is a digital or information sovereignty of Russia. For example, at the end of the April 2014, a member of Upper House, member of the it's so-called Senate of the Russian Federation, proposed establishing a separate internet, separate network, which is not accessible for from any other countries. This internet is named after this character. It's called Chepurashka. It's a Russian cartoon movie. And this Chepurashka net is a very funny concept for supporters of Russian freedom of the internet. But in general, there is a trend for sovereignization, state or regulation of the internet in Russia. Because there is no understanding in the essence of the internet as a global network. According to the Constitution of the Russian Federation, Russia is sovereign state, but its sovereignty belongs to its territory. So territory with its federal subjects, and territory of its sea. But there is nothing in this definition. There is nothing about the internet. So that there are serious problems with understanding that internet is truly supranational. And that's why there are different law initiatives, different bills, which are already adopted, which infringing human rights of internet users because of this kind of sovereignty. For example, there is so-called blacklisting laws, which providing some blacklisting. Primarily, it was to protect children from sexual abuse, from suicide, and that's why law enforcement authorities receive a right to block websites on the territory of Russian Federation without any court order. There is Roskomnadzor, it's called this Russian authority of under auspices of the Minister of Mass Communications. And according to these blacklisting laws, there are lots of websites already blocked within the territory of the Russian Federation. I would like to stress this blocking is extrajudicial, so without any court order. Another one is localization of personal data of Russian citizens. It's not possible to understand who is Russian citizen on the internet, but in general, all personal data of Russian citizens should be stored within the territory of Russian Federation. Within the territory of Russian Federation. For example, when I buy a ticket, being abroad, I'm Russian citizen. I would like to buy a ticket, for example, from Rome to Rio de Janeiro. I should place my personal data within the territory of Russia according to this law. So this law has no legal meaning, but the social network LinkedIn is completely banned in the Russian Federation because of incompliance with this law. There is a kind of, some people say this is kind of trend to block Facebook. Because LinkedIn has no many users in the Russian Federation, Facebook does. Next one, the law of bloggers, but this law forcing by the civil society is what its enforcement was stopped in Russia now, but legislator keeps interest to control bloggers by equating their rights to the media. So each blogger which presence will be more than 3,000 unique users per day will be equated to the media, to the journalist, according to this law. And the next one, on the 1st of July this year, they will fully come in force, so-called Yarovaya anti-terrorist legislation. Any single message of the user should be controlled, should be stored on the server, and should be taken to the competent authorities. So it's kind of censorship of private communication of users. It's completely infringement. It is because of the war on terrorists. This is according to the Chinese experience, because they established the golden shield like a system to store everything within China. All services are completely blocked, like Facebook, Google, and everything. They have alternative services in China, and I believe that Russian legislator goes on the same way. Internet governance experts says that it is governmental fragmentation, which is a general threat to the essence of the internet as a global network, and this is a problem for using internet within several countries. Like as we know, we have no internet, for example, as we know it in North Korea, for example. There are the consequences of the fragmentation. You could read this like attacks on service and other. I'm finishing. Just, like termination of the intergovernmental international transfer of data. And I think this is the last slide. I conclude there is no Russian or any country's segment of the internet. The internet is truly global, and we should understand this fact, and legislators should understand this fact. And the possibility of closure of internet is not protection of security, it's infringement rights of citizens, and we should find a balance. Thank you very much.
Thank you very much, because many times in the digital rhetoric narrative it's emerging. Digital law, it's part of the legal system, so we should reflect on the classic categories of constitutional law that are just applied the new technology. For example, in this case was sovereignty and territory that are many times forgotten in internet, but these shows that are really present. For example, with regard to sovereignty, have you heard about the Russian experience? Basically, in 2015, there was the petrification of dissent against European Convention of Human Rights, European Court of Human Rights. Basically, Russian legislation adopted, it was adopted legislation in which the Constitutional Court has the right to disobey to a judgment of the European Court of Human Rights. This is something quite important, because it's, I think, a dangerous step in the judicial dialogue narrative, because there is a petrification of dissent. This is the first thing. The second point is that our speaker underlined that borders matters, even in internet. Think about what they said about Russian legislation. Basically, they want to make a Russian internet, and this is against every claim of cyber anarchy. territory matters, and unfortunately matters too much. This is why fundamental rights protection should be taken very seriously, because it's really the only reaction to the over-regulation of the internet. I think this will be also discussed in the conclusive remarks. Now I stop and I give the floor to Giovanna for introducing the next speaker.
Many thanks, Oreste. Now we have with us German Turel. German Turel is one of the first follower of this group, so we are very happy to have you with us again, and I hope also for the future. Some words about his profile, lecture at the University of Murcia. Correct pronunciation?
Yes.
I'm sorry. A European PhD in law from the University of Bologna and the University of Murcia, with the thesis of the struggle of the law against Holocaust, negationism and dangerous warfare. Then he also won a prize with this thesis. Scholar at the Royal College of Spain in Bologna and a fellow at the Spanish Constitutional Court. Branches of specialization in law, I don't read. And here with us for a speech on the internet, incitement to terrorism and freedom of expression, the European framework. I permit just to say one thing, very beautiful as has been everyone, excellent. In this case, pay attention when he talked about the very thin line of border, line of division between freedom of speech and
Glorification of terrorism.
Glorification of terrorism.
Apology of terrorism.
Or provocation, because in this case there is the important for constitutionalism, constitutional law, the division between the exercise of fundamental rights and, on the other side, commitment of crime of an illegal act. Please, German, you have your 8 minutes.
Thank you very much, Professor De Minico, also Professor Pollicino for hosting this research group. Also thank you, Giovanni and Miriam, for all the emails, all the stuff that you have sent us in order to organize this meeting. And I apologize, I don't have this nice presentation, PowerPoint presentation, this nice slide, just my not very good English and this sheet of paper that I hope to understand myself. My paper is focused, as it has been said, on studying crimes of incitement to terrorism from an European perspective, including indirect forms like glorification and also what we call apologia of terrorism, related with the internet, because today the main via that we spread this kind of speeches is precisely the internet. But I have to say one thing. I need to cut the presentation, this oral presentation, and I decide not to speak about the internet in this presentation. You will find information about the particularities in the paper, and I will focus just on the limit to freedom of speech in these cases. Any one of you could think that this is an useless presentation, because as it has been said by Professor De Minico in her presentation, we have a regulation of this topic in Europe. We have an European directive, actually 1 year ago, 15 March 2017, the European institution approved this directive with an offense of public provocation to terrorism. And it's true that this directive is clearer and goes deeper than any other international agreement. We can find resolution of the Security Council, we have an European Convention, but it's true, this directive is clearer, it goes deeper. Also, regarding the internet, the directive set measures to eliminate and block internet content which contains incitement to terrorism, and also, as it has been said, we have Article 21 related the protection of fundamental rights, and in particular the protection of freedom of speech. So, is this paper useless? I don't think so. And it will try to show the deficiencies of this regulation. I will try to defend that we need to assume a higher standard of protection of freedom of expression, and as a consequence, the offense designed by European directive is not adequate, in my opinion. It's true, the European directive follows the European Convention, and I think it respects the Strasbourg case law. And here is the problem. We need a higher standard of protection to freedom of expression in Europe, following not the Strasbourg case law, but the US case law. Brandenburg, as you have said in this presentation. In short, what Strasbourg has said about this topic? First, a priori, it's possible to punish incitement to terrorists, but also these indirect ways like glorification or apologia. It is possible to punish them, but we should know that we have in these cases an interference on freedom of speech. And in these cases, we have to apply the triple test of Strasbourg. First, the interference should be provided by the law. Second, should have a legitimate aim. For example, the Strasbourg Court has recognized national security, territorial integrity, prevention of crime as legitimate aims which justify these kinds of interference. But third, the most important, the key point, in judging whether the restrictions are necessary in a democratic society, the Strasbourg Court holistically reviewed the facts of the case, including both the content of the speech, the context, the media, the people, all the things. But the problem is that the Court of Strasbourg has not provided a clear blueprint in relation to the degree of danger that justify this kind of sanction. It judges the ability or the capacity to incite, but does not judge the specific causality between the speech and its probable outcomes, the greater or lesser probability and imminence of verifying the damage, the actual level of danger of this kind of speeches. Here is the difference with the criteria followed by the USA Supreme Court, the clear and present danger test, Brandenburg versus Ohio. It is not enough with a general capacity to incite. If we want to proscribe a speech, we have to prove that there is a clear and present danger of an illegal action. And following this test, I have to conclude that although the recent European directive has made progresses, they are not enough. For that reason, you can find in the paper a particular lege ferenda proposal. I will say in a few words. First, I think that any form of provocation must be punishable. Also the glorification, also the apology, incitement. But it should be a public provocation. Here we have a problem with the internet, because public could be a website, but if I send an email to 1,000 people, if I have a closed group, a chat group on WhatsApp with that 100 people, in my opinion, it's a private channel of communication, but it's also a public dissemination that should be also recognized of that. 3, mens rea. We can punish apology, but there should be an intention to incite. Also in this indirect way, but this person should have the intention to incite. And fourth, the most important thing, the definition of the danger. This point, and I agree with UN General Secretary. Terrorist provocation can only be punished when it is directly causally responsible for increasing the current likelihood of a terrorist act occurring. And in addition, following the Johannesburg principles, it is necessary to prove that there is a direct and immediate connection between the verbalization and the likelihood of such violence. Contrary to this paper, will be opposed ground of efficacy and the excessive restriction of the punitive scope. You can say that the criminalization in these cases is not enough for fighting terrorism. Faced with such consideration, we must be aware that the clear recognition of freedom of speech involves risk. But we must have faith in the maturity of our societies. And it is this confidence which leads us to understand that when the risk is not clear and the danger is distant, then our response must be more and better speech rather than repression. In fact, the censorship of this type of speeches may have contraindication. For example, we have been talking about the dark internet. If we censor these kind of speeches, they are going to go to this dark internet, and we are not going to know that they exist, and we are not going to be able as a society to combat in many other ways, not just with the punish. For that reason, I think that we need to fight against the barbarity of terrorism, but without abandoning our principles of civilization. Thank you very much.
Many thanks also to German. Just one word, not to comment, I don't permit to comment. We have listened to internet as a reality with a double phase. On one side, it can be considered a great infinitive land where everyone can exercise his fundamental rights in order to develop own constitutional dimension of a human being. But on the other side, as German has illustrated us before, it can be a very powerful tool in the hand of a terrorist to disseminate the dangerous ideologies. And so what can we do? Not we, but what the supranational legislator can be do? One solution we have listened before, close website, clean internet from illegal content. The other idea that at the moment I haven't listened to anyone, but it isn't bad, of course, can be to leave everything on the web, on internet, because there is the marketplace of ideas, and the food, I suppose, not very well, also other, of course, is a very ancient American idea. So internet as antibody to react against illegal. Now I want to give the floor to my colleague, chair with me, co-chair Oreste Pollicino. I want to say that this event has been also the occasion for me, I don't know for Oreste, to know him well, to talk with him, not in every occasion we agree each other, but it has been a great occasion to work together. And I think I I really believe in what I'm saying. I am not cheating, not lying. I think that this occasion could be a great chance to know each other and to work together, because it's very important in our work to work together. Now, just a few words for Oreste. I should talk a lot, but just a few words. Bocconi University, of course, Milan, Italy, full professor of constitutional law. Teaching and research field, public and constitutional law, fundamental rights, media law, privacy law, information technological law. Publication a lot, just to quote some: protection of fundamental rights in internet, in judicial interaction, then with Romeo, internet law, protection of fundamental rights and the constitutional adjudication, with Minico 2, the first interaction between the European legal system, and the second, the national judicial treatment of the ECHR and EU rules. I give the word to Oreste, not for conclusion. He wants to do something particular. My introduction has been particular, his conclusion has been particular.
Thank you. Thank you very much, because it's I broke it. It's no, it's already destroyed. It's a nice way to not to make conclusive remarks, because it would be boring, but to try to open the discussion in a way that is possible to let emerge a kind of fil rouge among the speech, I think. And it's an easy job, because I think there is clearly a fil rouge and some common features that emerged already from the first speech, the first presentation of Giovanna. Basically, reminds me when Judge Easterbrook, in Chicago in 1995, one of the first conference on internet and the law of the cyberspace, make an interesting analogy: law of the horses or law of the animals. It was basically provoking, saying, why we should speak about the law of the animals with regard to internet, why we should speak about the law of the horses, the category of animals, if we have a general categories. We have the law of the animals. Why we need a specific subcategory for the internet? And this is clearly emerging in this in the discussion. We have the classic category of laws, and we have new technological tools. The point is how the classic categories should be encapsulated, sometimes changed, but not totally changed by the technological dimension. This, I think, it's interesting, because otherwise we lose totally the moon focusing really on the finger. The finger is just a tool. It's a technological tool. But let's look at how classical categories are shifting, still keeping the original meaning. Think, for example, to the introduction of Giovanna De Minico, when she speaks about security and law of the fear. And basically, she proposed that interesting imagine, the one of the constitutional accordion. What does it mean? Constitutional physiharmonic, if I understood correctly. Basically, the flexibility of the emergency that should enable the state to go back to the physiological structure. This is very interesting, and I think it goes quite well with the idea of Fulvia Abbondante when she presents again, another metaphor of marketplace of ideas. The marketplace of ideas, and I will come back to my conclusive remarks, should be handled carefully, because it's a metaphor. The metaphors are very nice. They give a lot. They in a way helps to visualize things. But if they are not handled carefully, they could misleading. They could be really misleading. But I will come back to it. Let's try to understand which is the basic concept in Fulvia. It's how should public powers deal with the new technological challenge? Which kind of regulation is the most appropriate one? Self-regulation, co-regulation? When I'm at the European Commission dealing with fake news, this was mainly the question. Is self-regulation enough? I don't think so. But the problem is that we should define identify legal basis for dealing with the hard law with regard to internet. Unfortunately, European Union has not as an exclusive competence media, like agriculture or competition. So it's not an easy task. Otherwise, the Commission will immediately identify that there is not a legal basis. European Court of Justice will kill the legislation. And then there was this idea of Shulamit that, as she usually does very well, she let us see things through images. And images was the allegory of how law is shaped by artificial intelligence and by how human being is related to the new technology, how it's related and how the process of, if I can, dehumanization it's going on. Because it is very interesting which part of human dimension is keeping in the artificial intelligence. This is the question. And Mary is answering not so much, because at the end it's very difficult to understand which part of the body remains human and which it's going digital. But the problem is that emotional, culture, fears are still very human and are used by machine, not by machine, but human behind the machine to control, to influence, sometimes democratic process. I mean, thanks to Cambridge Analytica. Cambridge Analytica is a clear example in which personal data are used, are manipulated in order to pollute the debate of a democratic society with regard to election. So basically, data protection is not anymore that the right to be left alone, but is exactly encapsulated in a public arena in order to change the result of a political debate. And then there is the problem of economic powers. Giovanni De Gregorio, economic powers and freedom to conduct business that is shifting in a private power. It is a challenge for constitutional law because we are used to deal with public powers, and the main challenge of constitutional law is in a way to limit powers. But we are used to limit public powers. It's at least theoretically the only one legitimate. Now we are dealing with economic private powers that needs to be in a way assessed through a new conception of fundamental rights, if you think about. Not anymore vertical application, but maybe horizontal application of fundamental rights. This is a little bit difficult in the United States, because there is something called state action doctrine. It's not impossible. I will come back in the last 3 minutes. In Europe, where is the dignity, the constitutional paradigm is not just liberty or equality, but clearly law of the platform matters. And the new season of the law of the platforms, it's again the usual dilemma. Which kind of regulation? Ex-ante regulation in order to avoid any kind of surveillance? Maybe, but there are two problems. The first one is the chilling over effect on freedom of expression, like Jack Balkin has shown. Secondly, it's against the law, because the Directive of 2000 doesn't allow ex-ante monitoring, at least in Europe. So we have to deal maybe with ex-post monitoring. But the ex-post monitoring could change a lot in relation to how quick should be the platform to remove. And this is interesting because it's exactly the German experience that is teaching us there should be maybe too quick, 24 hours. I mean, it's not a big deal for the giants, but the startups should change their business model in order to really comply with this obligation. And then it's interesting how Maria Francesca De Tullio is dealing with participation, inclusions versus exclusion, if you think about it. She spoke about how democracy it's basically based not only on the respect of principle of equality, but also to keep in mind some values when digital economy allow to accelerate, to forget about these values. I mean, to going global, it doesn't mean to be more democratic, not at all. Sometimes it's much more democratic than local values. And so we have the usual dilemma, universalism versus local values. It's a clear problem in constitutional law, but also in digital law. Again, law of the horses or law of the animals. And then Maria Orefice, big data. Big data, what does it mean, big data? And how big are those data to be considered big data? Are just so big that they are not personal anymore? And this is important because as the cultural approach, the European legislation is based on personal data. This means protection of data that are just able to identify a single person. But when those data are not able to identify the person, but still are used to a tool of control and potentially influencing democratic debate, are still covered by the umbrella of legislation, maybe not by the secondary legislation, but for sure by the Charter of Fundamental Rights, Article 7 and Article 8. And then we have the Fourth Amendment of the United States Constitution, and this interesting exercise of Supreme Court to look in the Fourth Amendment what there is not at all. There is not privacy, but still, it has been mentioned, Rose versus Wade, 1973, but also Jones, 2012, it's possible to look at not anymore at the physical trespass, but at the trespass that is not physical, but is digital. I mean, what is important is basically that in the judge of Supreme Court, think to Judge Sotomayor, I mentioned already in Jones. She's presenting a theory, mosaic theory, that is much more, I would say, updated to deal with big data than the big GDPR, the European Regulation Data Protection. Why? Because it's not based on personal data, but just on data. The quantitative aspect is becoming more important than the qualitative. I'm not sure it's a good idea, but this is the trend. Like, for example, Rosario Serra let emerge very well the data exchange measures in order to challenge with the phenomena, for example, of migration or controlling for security reason over name records register can be a tool to basically affect totally data protection and privacy of single persons. And the problem is, again, here, which is the degree of protection in Europe and which is the degree of protection in the United States? Are they equivalent? This is an interesting question because the legislation in European Union doesn't speak about equivalence, but about adequacy of the United States legislation. The European Court of Justice manipulated the legislation in order to speak, it changed totally the criteria, not anymore adequacy, but equivalence. You remember, the equivalence is part of the grand array of the judgments of the European Court of Justice and of the battle with the Constitutional Court. Solange 1, Solange 2, Frontini, it's about equivalence, but also Bosphorus between Strasbourg and Luxembourg. So let's say there is a kind of constitutional frustration of European Court of Justice that in a way it's letting emerge in this narrative. Another narrative of our Russian friend, Andrei spoke about sovereignty, about how analog sovereignty discourse is shifting in digital one. But still the idea is to let emerge borders in a phenomena that should be transnational by definition. But transnational doesn't mean that is allergic to regulation. You remember Barlow, 1998, Declaration of Independence of Cyberspace. Mm-hmm. It was very interesting. He died recently, but he was unfortunately very naive. Not only like Goldsmith proved in the who control internet states can control, can even over-regulate. And again, Charter of Fundamental Rights becomes very important here because it's a limit to over-regulation, and the constitutional law is rediscovering its first mission to limit power, not only public but also private power. And I think this is quite interesting. Like it was interesting the final conclusion of German Lozano. I'm not totally agree with your view, I should say the truth. I think that we should not only proud of our European roots of freedom of speech, but I think it works quite well. Why? Because if you think about the principle of proportionality, Article 52 of the Charter of Fundamental Rights and the triple test that you let emerge, it's crucial in Europe, the idea that freedom of speech could be sometimes limited, more than the United States. For a simple reason. The United States is based on the principle of, I would say, liberty, freedom. First Amendment is the, I would say, amplification of freedom of liberty. Whereas European Union is based not only Article 1 of the German Constitution, but look at the Charter of Fundamental Rights, but also to the concept of abuse of law in the Charter and the Convention. But this is something else. What is interesting, I think that we should, again, handle carefully metaphors. When you speak about marketplace of ideas, you speak about that metaphor that Judge Holmes presented in the dissenting opinion in Abrams. That is very interesting in that context. Which was that context? The context was that in the idea of metaphor, metaphorein, carrying over, we bring something from a source area and we carry on a target area. Which was the idea? The idea was that there was the freedom in the economic market that in a way was confirmed as a market of ideas, market of information that was totally free by private powers. It was basically a market that was totally open to free market competition. Look today at the internet market, digital market. It's really so free, it's really so based on competition. We mentioned private powers. This is not only a question of competition, it's also a question basically of new powers that are emerging. Now, if we decontextualize totally this metaphor and we shift from one part to the other part of the ocean, the risk is to be misleading, because I think that today that kind of market that Holmes had in mind, and also the Supreme Court in Reno, when it calls internet as a new free marketplace of idea, is far from being free. And this is the reason why public powers has a role, and likely constitutional roles has a role as well. Thank you very much, and we open the discussion.